March 13th. We are now going to look at H410 momentarily. Once we are all set.
Successfully swallowed.
Okay, H410, over to you, Ben.
Just logging on now, and I think Nate is working his magic.
It's not yet.
Good.
Yeah. Here,
You're all set.
you. Oh, sorry.
Hey, Ben, heard about the nice. You like the gentle soundtrack back there.
Yes.
Okay.
I like the one on this end of the table. Well, I'm glad I could help the committee get into its zen.
Okay.
But for the record, my name is Ben Novogrodsky from the Office of Legislative Counsel for the committee. Today is H410, which is an act relating to the calculation of recidivism and other criminology measures. Essentially what this bill is doing is redefining the current calculation of recidivism. And that current calculation right now is essentially you calculate the rate of recidivism based upon offenders who are sentenced to more than 1 year of incarceration who, after they've been released, return to prison within 3 years for conviction of a new offense or a violation of supervision, and the new incarceration sentence or time served for the violation is at least 90 days. So you've been convicted, you're sentenced to more than 1 year of incarceration. And then if you commit a crime or a breach in supervision within the following 3 years after release, and the time for that violation is at least 90 days, that is the current calculation. So it's super simple. But what this bill is doing is, I think it would be a fair assessment to simplify it a little bit. So the way that they're doing this is accomplished in a few ways. So in section 1, amending 28 VSA section 3, which is the definition section of the correction statutes. So you'll see here, nothing on the first page. You'll see on line 8 of page 2, a little nod to work crew, which is now being referred to as community restitution in the law. So that's being changed.
By the way, just I want to pause right there for a second because, and I apologize for this tangent, but I'm going to forget again that on work crew, corrections is designating 2 or 3 members to get together with 2 or 3 of our members to figure out work crew. So Tom, are you willing to be one of our people for that? Who else would like to be part of that? I only need one more person. Work crew. All right. Third person. Barbara, do you want to?
Sure.
And Barbara. All right. So thank you very much. I will let them know and they will coordinate to talk to. I mean, obviously it's not happening by tomorrow, but it's going to be a continued discussion apparently. And that was Alice's request about it. Oh, and I just. So thank you. Sorry. Back.
Oh, it's okay.
Regularly.
So that change is really just a technical change to align with other statutes. But then you'll see at the bottom of that page, starting on line 18, there's now a definition of recidivism that is included. So this would mean a person who's convicted of a criminal offense after receiving a criminal conviction for a previous crime. So it's a lot simpler of a definition. And then there's another new definition of repeat violent offender, which means a person who commits repeated criminal offenses for which the crime type against another individual is considered violent. And the reason why that definition is phrased that way is that crime type is something that the Department of Corrections uses in its calculation of these. So it's sort of so that the statutes are speaking the language of correction, so to speak. So that's why it's there, but and I'm sure this committee is well aware, the definition of violent crime is squishy. And so rather than trying to survey all of the statutes and saying these certain crimes are considered violent or not, this is sort of where the language of the bill landed because it's part of the data collection that the department does already. So it's theoretically an easier lift for them based on the crime type terminology that they use.
Yeah.
Okay.
So does that mean that there's a list that exists through corrections now where they have designated which crime types that are considered violent?
I don't know if there's a list, but in what I've seen is that they categorize it. So they'll have like a crime against a person, crime against property, and then violent, non-violent. And I think, so the short answer is I don't know.
So it could just be their jargon.
Yes.
But I guess what am I trying to get? Like, to just be able to tell, like, for this, doesn't help me to know, like, what does it mean for a repeat violent offender? Like, I want to know a specific charge to it. But it would be on a case-by-case basis, is what it sounds like.
Yeah, and the way that this is interacting is that this bill creates these definitions and then uses these definitions in the next section to classify and calculate how they're determined. If that makes sense.
So, yeah, I appreciate, I'm just gonna flag it, because I feel like that's something to understand more, but it doesn't get in the way of.
And I would defer to, I think, CRG is,
Okay.
because they do a lot of the analysis of this, and then also the department itself, because they source most of the data that the judiciary relies upon when it comes to these type of issues. So, it might be good to get their thoughts on it.
I've just texted Nate to make sure we try to get somebody from DOC, but I know that Robin's supposed to be available later today. Barbara, go ahead.
And do we know, I don't know who to look at for this. I mean, recidivism rates are used in like national, federal, Office of Department of Justice, they were, materials. And sometimes we're like comparing with other states. Do we know if this at all lines up with that? Like, given corrections, maybe it's a DOC question. Like,
Maybe. I don't know the answer to that. What I can say is that this bill, the Department of State's attorneys, CRG, and I feel like there was one other entity that
Attorney General's office, CRG, and State's Attorney.
right, got together and kind of came up with this language.
Okay.
Yeah.
good to know.
But I don't know how it compares to other jurisdictions.
We didn't ask Kathy Fox.
I did not.
I just wondered.
I mean, we can see if he's available to testify as well.
So I can move on unless there are any other questions on this.
Do you want to wait? I have a question on this, but I can wait for you.
Yeah.
I'm wondering, I mean, like, that's such a squishy definition for repeat violent offender. Did you think about maybe borrowing the language from like the bail review for violent offenses, like that where there's an element of a crime that has a
I
violent.
mean, that's a possibility that could be incorporated. I think this is sort of just to be transparent, I think it's maybe another way to get to it, but for the sake of consistency, there's probably merit to that. But that's through the testimony that I've heard through the last few years. That's why it's hard to really define what's a violent crime. It's not because many different crimes have an element of violence, but may not fall into a nice definition of what a violent crime is.
Yeah, so maybe it's hearing from DOC about it. And then I think the only other question was, should this be means a person who is convicted of repeat criminal offenses?
This is what was decided upon by CRG, DOC, and the agent's office. So it was commit, so it could be convicted, but this was the language that I was drawing from.
Certainly make
The crime research group, which is
and Todd.
by Vermont's Fiscal Analysis Center, that I think is held,
Sorry to interrupt.
housed within. Yes. But I'll make notes of that. Okay. So moving on, the rest are just technical definitions for numbering. In section 2, is where the bill amends section 4 of Title 28, and you'll see on line 15, it's no longer just the standard measure of recidivism, it's the standard measure and classifications of recidivism and repeat violent offenders. Subsection A is entitled recidivism, and then within that, you'll see classification. So within that, the language is changing that the department shall classify the type of recidivism based upon persons who are convicted of a criminal offense and meet one of the following. Class 1 recidivism is that not less than 1 year has elapsed from the time of sentencing before the person commits a new offense that results in a conviction. Class 2 is the same language, but 3 years have elapsed. Class 3 is a 5-year period that has elapsed. And then class 4 is not less than 10 years have elapsed. So that's kind of the structure, is that you now have 4 classes of recidivism, ranging from those who recommit after sentencing within a year, within 3 years, and within 5 and 10.
Know if this is a common setup in other states? Okay, well, we'll ask our other ones. Yeah, go ahead.
I think you might have said this right. I apologize, but it feels like it's Groundhog Day anyway. So because it says convicted of a criminal offense, would a violation of a condition of release be a criminal offense?
If they were convicted, if they were charged with a violation of condition of release, so a VCR, and then convicted of that, yes.
Even if it's not, like if it's a curfew violation or something?
Yes.
Yeah, if it was charged that way, no. Violations of conditions of release can kind of be handled up to the, within the discretion of the prosecutor, so
Right.
they can choose
So at
to
least it's
prosecute.
not a crime per se, other than it being a condition.
Well, the violation of a condition of release is
Is
a
a
crime.
crime, right?
If it's charged that way,
For a
but
while there was a big discussion about that because people were like, which condition, but I think being late for like their.
Technical.
Right.
Technical.
so oftentimes another option though that a prosecutor would have is if there's a violation, they can just move for a bail hearing, which would be a new hearing under the bail statute. So it's not a new charge. It wouldn't be a conviction, but it can just say, okay, listen, what we have
Right.
imposed upon you isn't working.
Right.
Let's reassess.
So,
And that would not be covered by this.
okay, all right, thank you.
Subdivision 2 are the calculations. So a person sentenced to incarceration will be considered, excuse me, considered eligible to recidivate upon release from a correctional facility. Person sentenced to a non-carceral, carceral, thank you. It's a funky word.
Say it loud, please.
Sentence are considered eligible to recidivate on the disposition date of a case. So this is really just setting sort of where those calculation points begin. And then finally, in subdivision C and D, a conviction will determine whether a person has recidivated, and D, the arraignment date associated with the conviction will determine the recidivism classification. Any questions on sort of those start and end points?
I kind of,
Yeah,
I don't know if it's,
yeah.
it seems like most of this stuff is going to be used interiorly or within corrections and not anywhere else. Maybe in a sentencing hearing when they're talking about their recidivism rates or something like that. I don't see somebody saying, "Oh, he's a class 2 recidivism rate or whatever." I don't know. It just seems like this should be done by corrections to fit their model
Well,
that they do their investigations on. And
so I mean, they're gonna have to have at least a flyby down the hall. But also we're trying to get DOC in tomorrow.
they're the only ones I see using.
See, I guess
most of this.
So I definitely see CRG using it.
They might want
I
it to
see what-
quantify things a certain way.
Well, and I mean, the legislature wants to understand how we should be measuring recidivism to.
Can't they just give it to us in raw numbers, or are they gonna give it to us in groups of class 2, class 3?
No, let's ask two things. No, it's a good question. I mean, so I'm taking this up because I heard from state's attorneys that this is one of the things they wanted. That it came from state's attorneys, so I didn't actually go to DOC. And then that also got into the omnibus bill, much to Ken's chagrin, it's now in this bill, but that's okay. So it came from state's attorneys last fall. We started looking at this like in September, before there was even a thought of a omnibus.
What number is this bill?
It's 410.
410. And what was the other number of the bill that we were picking up? 407?
409.
409.
Are you thinking 420 is coming
I
up?
think what you want is 411.
411. I'm just wondering how these came up before.
I said-
the other one.
I thought you were looking for.
Sorry, we digress. But so anyway, let's ask state's attorney what their need is. And I know that crime research groups need, I understand.
Poking its head up in court in like a pre-sentence investigation or something, but that's where it would start again in corrections hands. They're gonna develop.
Right, corrections definitely.
So I mean, it should be just one. Does it work?
Go ahead.
So in general, like when I've worked at organizations, like we could say, here's the way we want to measure our success. But when it's sort of done only internally and defined internally, a lot of people don't accept it as being valid because it feels like it's too skewed to prove our own success.
My only thought is, what if it isn't a good template for their use? So,
Right.
Yes,
and then it comes out and no one likes it. So,
That's why we definitely have to hear from DOC. Yeah, and yeah.
So just on making sure I understand the calculating for each of the classes. So for some of these, it'll probably be like a fairly long time until you can actually capture.
It could be.
Yeah, so because if you were charged with an offense within 1 year of being of a sentencing in another, then you have to wait till the conviction happened on the second offense, and that could be years out, which would still qualify for the 1 year because it's based on the day of arraignment.
Right.
Okay. What two things I'm curious about for like deferred sentences where they have it for a while and then they don't have it anymore? Do you think that would that count towards this because they would have a conviction?
I'd have to look into that some more.
And then for probation violations,
So probation wouldn't be,
it's not its own.
so probation isn't like an incarcerated sentence.
Yeah.
So, that would be the starting point from, say, disposition of the case. So I think like in 2B,
Yeah.
they would fall under that.
Yep.
So that I think situations are contemplated.
Yep.
To account for those various ones. But I'd have to a little bit more time to think about the deferred sentence aspect.
I don't really know how that would work, but I think it makes sense. Yeah. Okay.
could have a pending clause on the end.
I don't even know how, I don't really know how common this difference is.
Any other questions before I get into subsection B?
This is a more general question. We're just doing this for people who are charged in. Not, but I guess I'm wondering what's happening to people who are under age 18 or whatever.
So these would only be for criminal convictions, because those, if they're charged in family court, those are like delinquencies or,
Not,
so their adjudications are not necessarily covered as
we're
conviction.
not changing the definition for recidivism for those types of cases as well. We're just doing criminal.
I mean, it doesn't explicitly exclude them, but the terminology used of conviction.
Right. Is not.
Yeah, exactly.
Okay.
Yes, okay.
How would expungements happen with this? Like if
What do you mean?
so, because you have one, you have an conviction, right? And so that's the starting base of when you start the clock to figure out which class of recidivism you're in. So then you might be a class whatever for recidivism, but then this underlying thing gets expunged.
Right.
So is it now you're no longer a recidivism? You
I mean,
know,
it would probably be hard to calculate because at that point, they may not even, it's as if it never occurred.
Yeah,
So I think it would be hard, if not impossible, to make that calculation.
I seem to recall we dealt with that somewhat in the ceiling bill.
We
And
did.
we will be seeing that very, very soon.
Okay.
And that's my same question with the defer, right? So you have it for like a certain amount of time and then it goes away. So like, how would we calculate?
It is here.
Yeah, same thing on our-
Caveat, and that's the only
I mean, these are all like the little exception things for it, but
Yeah,
I mean, but
not
that's
trying
more
to take this
for.
apart, but it'd be interesting to hear witnesses' grades out of that.
Well, no, it was more for research than it was for the other survivor. But we'll find it very soon. We're gonna get language, 40-some page bill or 50 or whatever it is. So yeah, go ahead. Ben, next
Okay.
part.
So subsection B concerns repeat violent offenders. So the department calculates the rate of repeat of violent offenders based upon individuals who are convicted of a criminal offense and meet one of the following, and it follows a similar calculation pattern. Class 1, not less than 1 year has elapsed from the time of sentencing before the person is convicted of a violent offense. But I think we've discussed how that's a squishy term. Class 2, not less than 3 years have elapsed. Class 3, not less than 5 years have elapsed. And class 4, not less than 10 years have elapsed.
This makes sense. So just on line 5, does it need to be that it is a violent criminal offense that sets this off, or is it any criminal offense you're charged with and then you have a violent after it? Or it seems like it would need to be a violent to start to show that it's a repeat violent offender.
The way it's crafted is that I don't think it would cover the initial.
What?
I'm just trying to.
Yeah, it wouldn't cover, so if they were convicted of any crime, it wouldn't have to be a violent crime. It would just be if that second offense
Was violent.
was violent.
They would be considered a repeat violent offender and they've only committed one violent offense.
They've upped their category by.
That is, I don't know if I agree with that.
And again, I mean, the way this interacts with the repeat violent offender definition, there's always room, I think you could clarify it or make it more explicit if you want to. And so section 3 is amending 28 VSA, section 125B. Sure, everybody remembers the S14 report from a couple of years ago,
Oh, my God.
or Act 40. What this does is so that's a report that sunset, I believe, in 2028. It's changing the definition of recidivism in that statute, which governs the report to match the definition of recidivism in this bill. And just for context, that report is essentially a holistic look at the trends of the criminal justice system to see if some of the policy initiatives that the legislature has enacted are trending in positive or negative directions. And CRG is the author of that report. So again, sort of they have their hands. And then section 4 is that the act takes effect on July 1st of this year.
Any other questions for Ben? Ian, go ahead.
just going back to what the definition right now of recidivism is.
Yeah.
So that I can understand when we're talking to the witnesses. So before we did, or right now, we don't make a distinction between a felony or a misdemeanor or anything like that. But we do say that it's got to be somebody who's sentenced to at least 1 year in prison.
Correct.
The proposed change to recidivism doesn't make any kind of distinction at all. We're literally saying misdemeanors, felonies, incarceration, no incarceration, given the dismissal date for something that you didn't go to jail for at all. We're just trying to capture everything. Okay.
Yes.
Okay.
And from my understanding in the research I did and the conversations I had, is that the vast majority of sentences aren't very long.
Yeah.
And so I think that the implication is that they were missing out on a lot of data
Yeah.
that could be useful.
Yeah, yeah. Okay.
Other questions tonight? Right, not seeing any, and we don't have another witness quite ready yet. So we're gonna adjourn until 3:30, and at 3:30, we're gonna vote on H222, because I've reached out to Burdett to tell him that if he wants to vote, he can get on